On August 20th, the Northern District of Texas held that the Federal Trade Commission's rule banning non-competes was unlawful and set the rule aside on a nationwide basis. As a result, the rule will not be enforced or take effect. The rule was originally scheduled to take effect on September 4th, 2024. At a high level, the rule would have banned non-competes, except in the sale of business context, and voided pre-existing non-competes for most workers, except for senior executives. It also would have required employers to notify workers if their non-competes were void under the rule. As we've discussed in previous LaborSpeak videos and articles, despite the fact that this decision was issued just weeks before the non-compete rule went into effect, the rule never had much of a chance of survival. The numerous issues with the rule were discussed in the Texas court decision and another recent decision from the Middle District of Florida enjoining the FTC from enforcing or implementing the rule against the plaintiff in that case. The Texas court held that the section of the FTC Act that the FTC relied on to issue the non-compete rule does not grant the FTC the power to issue such rules, and that the rule was arbitrary and capricious. The Florida court preliminarily enjoined the rule under the major questions doctrine, holding that the rule was one of extraordinary significance and that the FTC did not have the authority to issue the rule. A Pennsylvania court that heard a challenge to the FTC's rule found differently. That court sided with the FTC, holding that the rule would not result in irreparable harm to the plaintiff challenging the rule, and that the FTC had the authority to issue the rule under the FTC Act. So what happens next? The FTC is considering appealing the Texas court decision to the Fifth Circuit. However, the Fifth Circuit is notoriously business-friendly and agency-averse, so the FTC's chances of success in that circuit would be slim if it appealed. Further, the FTC may not want to appeal a case it is not likely to win, to avoid a higher court decision that limits its authority. Neither of the two ongoing cases in Florida and Pennsylvania seem to be moving quickly. The Florida court granted a motion that would delay pleadings while the FTC considered its next steps and would require the parties to file a joint status report by September 25th. The Pennsylvania court issued a scheduling order with summary judgment motion deadlines through November 26th. If those cases continue to play out, a circuit split could develop, which would make the case ripe for Supreme Court review. But the rule's chances of survival likely would not improve if it was ultimately appealed to the Supreme Court, which just handed down the landmark Loper-Bright decision that took aim at the power of federal agencies and deference courts show to such agencies. While this may be the beginning of the end for the FTC's non-compete rule, the issuance of the rule itself put non-competes on the radars of legislators and courts across the country. As a result, we would expect more legislators to pass laws restricting non-competes and courts to become increasingly wary of the use of non-competes. Further, it is possible that the FTC and National Labor Relations Board try to step up enforcement against employers utilizing non-competes, but it is unclear if those agencies have or are willing to devote resources to such enforcement. Therefore, after breathing a sigh of relief that the FTC's non-compete rule was struck down, employers should continue to monitor legal developments regarding non-competes and consider reviewing their non-compete agreements to ensure compliance with applicable law.